So if you're a lawyer using the free versions of ChatGPT or Claude for your client work, you need to stop immediately if you want to keep your law license. So a few days ago, Judge Raskoff ruled in the United States versus Hepner that using consumer AI tools may in fact waive attorney-client or lawyer-client if in Canadian privilege. So here's what happened. A defendant used the free version or the unpaid version of Claude to create documents for his lawyers to review. The government moved to compel production, and Judge Rakoff agreed. And now the underlying principle here is relatively simple. You have attorney-client or solicitor-client privilege of the Canadian. This doctrine applies to communications between counsel and client. By providing documents or having an exchange with Claude that you then send to your lawyers, that's not necessarily confidential. Claude or these AI tools, there's no confidentiality provision, especially if you use the free or unpaid version. In fact, some of these tools actually explicitly say these are going to be used for training data. And this principle, the third-party disclosure without confidentiality agrees, that's the reason why privilege was waived. This ruling has a lot of implications, but at the moment, in my mind, exposes three risks. The first risk, obviously, is that lawyers should not be using ChatGPT or Claude for free. If you're going to be using these tools, make sure you pay for them. No matter what tool you're using, you need to be taking the necessary precautions to ensure that the data you put into ChatGPT or Claude or Gemini, that a court is not going to say, hey, guess what? You disclose it to a third party. The other party is entitled to get that. Because again, that disclosing it to AI, that is a third party, right? And so that's a significant risk that I'm still trying to work my head around. The third piece here is how your clients are going to use AI. So let's say that you do everything right. You draft a provision memo and you send it off to your client and you expect that your client is going to read it to provide you instructions. But not all clients are sophisticated. They might want to know if the memo has considered other issues, that they may need AI to help them translate certain concepts in the document. Arguably, based on the reasoning in this case, by doing so, the client has waived privilege and you yourself as a lawyer have done nothing wrong. If you are going to be using these legal tools, make sure that they do not use the data you input for training purposes, because if they do, that is how solicitor-client privilege is waived. The second piece here is that we need to be more diligent in speaking to our client and addressing it in our engagement letters, expressly advising them that if they are going to be using AI, make sure that they use the paid versions, and that if they're using the unpaid versions, they run the risk of solicitor-client privilege being waived. Now, if you want to ask a decision, I'm happy to send it for transcript. Just drop decision below and I'll be sure to send it on to you. And again, if you want more tips to help you integrate AI workflows into your legal practice, follow for more. Cheers.